Court does call the case of the people of the state of Michigan versus Robert Braxton.
Robert Braxton. Yeah, I think that's
yours, Mr. Brown, according to us. He's retained.
Good morning, Your Honor. Good morning, Your Honor. Chief Assistant Prosecutor Victoria Burton Harris appearing on behalf of the people.
Good morning.
Braxton? Is Braxton here?
Yeah.
Yes, I'm here.
Good morning, Your Honor. May it please this honorable court, David Burgess on behalf of Robert Braxton is appearing via Zoom from the Department of Corrections.
Mr. Braxton, can you state your name, please, sir?
Robert Braxton.
Thank you, sir.
Your Honor, I did speak with the people. We do have a resolution in this case, but we need to finalize it. I told Mr. Braxton the other day that we were going to resolve it today. He's not aware of this, but we do have the same resolution that I discussed with him before, but we are going to put this out. I believe that people are asking for 3 weeks so that we can finalize the resolution. Nothing has changed, Mr. Braxton. It's just a logistical thing.
Okay.
Yeah, you can call me later, Robert. I'll explain, okay?
Okay.
Probable cause conference will be adjourned March 27th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Thank you, Mr. Braxton.
All right.
Court does call the case, people versus Jermaine Jean Giles.
Ashley Lonnie for the people.
Good morning, Your Honor. May it please this honorable court, Rita Young appearing on behalf of Mr. Gene Giles. I did submit a request to go into a breakout room briefly with him, please, Your Honor.
No, I can't do that today. I got 140 cases. I can't have breakout rooms all over the place, and I don't allow it.
Very well, Your Honor.
Need an adjournment so that you can talk with him, then I'll grant the adjournment.
No, that's okay. Mr. Giles, would you place your name on the record, please?
Jermaine Jean Gillis, 975-851.
Your Honor, today is the date and time of an adjourned probable cause conference. We are requesting a preliminary examination hearing date, please.
Okay, and is all discovery complete?
I have everything except for I still need a copy of the lab results for the DNA testing done on a firearm on November 25th of 2024.
Yeah. And where are we with reference to those?
Your Honor, it's been my experience that oftentimes we will not get DNA on firearms unless it's a homicide case, which this is not. So I don't know that we'll have that, and I don't know that if we will have it, I don't know that we'll have it back in time for the exam. I don't know what STF stands for as far as where the defendant is located, but I'm going to ask for at least 4 weeks because we're going to need to do a transportation writ.
Judge, there were DNA swabs done, and so I would ask.
Are you going to need that to proceed to preliminary examination, because it's not going to be adjourned for that reason?
I would prefer to have those results, Your Honor, before we proceed.
Then what I'm going to do is I'm going to adjourn this out so we can at least see if those are going to be obtainable. I'll adjourn this to March 27th. Probable cause conference, March 27th, 2025, 9 a.m. Bond will continue. And Ms. Lundy, if you can check into the status of that so that next time we come here, we can figure out what we're going to do.
Yes, Your Honor. I'll connect with defense counsel offline.
Thank you, Your Honor.
Thank you. Court calls the case, people versus Jenny Liu.
Ashley Lonnie for the people.
Assistant Public Defender Chelsea Rigiels with and on behalf of Jenny Liu, who appears via Zoom. Ms. Liu, please state your name.
Jenny Liu.
Thank you. You're requesting an adjournment.
Yes, Your Honor. We've had a plea discussion. We have a proposed resolution. I was not able to meet with her before today, but we would ask for a short adjournment.
Probable cause conference, March 27th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Ms. Liu.
Thank you.
Court does call the case of the people versus James Sharp.
Morning, Your Honor, Raymond Cook for the people.
Yes, sir.
Who's on? Mr. Sharp, can you state your name?
James Sharp, James Glenn Sharp.
Who's on this? Where is he? Has anybody seen Mr. Fifowski?
Your Honor, I believe he's talking to a client in the detention room. I can go get him if you'd like.
Let me pass the matter, Bridget. We'll get right back to you, Mr. Sharp. Court calls the case people versus Terrell Green.
Morning, Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Green. Mr. Green, can you state your name for the court?
Yes, Terrell Green.
Thank you, sir.
And unfortunately, Your Honor, I was not able to speak with Mr. Green, who's in Jackson County Jail prior today, so I am going to have to ask for a very brief adjournment to do so.
He's in Jackson. How long is he expected to be there?
Mr. Green, do you know when you're getting out?
Hopefully tomorrow. I'm just here on the probation violation.
Not sure, Your Honor.
You have a hearing date for that yet, sir? Or have you been sentenced on the violation?
No, it's tomorrow. Hearing date is tomorrow.
It's tomorrow? All right.
Yeah.
Then I'll adjourn the probable cause conference to the 20th,
Thank you, Your Honor.
March 20th, 2025, 9 a.m. Bond continued.
I'll follow up with you, Mr. Green, okay? Good luck in court tomorrow.
All right, thank you.
Sure. Court calls the case of the people versus Philip Bass.
Morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Stephanie Can on behalf of Mr. Bass, Your Honor.
We mute Green.
He's in custody.
Where?
Bass.
There. Okay, there he is. State your name, sir.
Philip Lamar Bass.
Thank you. What are we doing?
Your Honor, an offer has been extended in this matter. So my client is going to waive over to circuit court. He's going to waive over to circuit court, Your Honor.
Sir, is that a correct statement?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
I understand.
All right. People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bounced over to circuit court on a single count. Ms. Taylor.
Thank you, Your Honor.
Thank you.
At this time, my client would waive formal reading of the information and stand mute as to the charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Trial in this matter will be set for March 19, 2025, 1:30, Judge Conlon.
Your Honor, could we address bond in this case? Thank you, Your Honor. My client is requesting to be released. He had been homeless up until this point. I did email that information and his current mailing address and where he can stay to the AG's office yesterday. He just was unemployed and homeless, which is how we get to the point where he's owing this money. However, my client got a job 2 weeks before he was picked up. As a matter of fact, he was meeting with his boss when he was picked up. And so my client just wants to get out, start working again, Your Honor. He has no problem once he starts getting
The
payments.
bond is set in accordance with the statute.
I understand you, Your Honor. I'm just asking if he could be released on PR to get out, because he has no money. He just started working. He'll never be able to get out at that point because he was unemployed and homeless up until 2 weeks ago.
I don't need a response. The bond is set at 25% in accord with statute. Motion for bond reduction is denied. Bond will continue. In both cases. Can you? Court calls the case People versus Lawrence Savoy.
Ashley Lonnie for the people.
Ready, Your Honor. Good morning. Dan Garrett on behalf of Lawrence Savoy.
Good morning, Your Honor. Lawrence Savoy.
And Mr. Guerin, as a Spartan, you are welcome.
We appreciate you as always, Your Honor. Thank you. Your Honor, there should be a green sheet in the file. We're asking for an adjournment so we can screen Mr. Savoy for 14B's recovery court.
And that's
Okay,
correct, Your
what's
Honor.
their-
I've agreed.
I'm sorry, Mr. Lundy.
I've agreed, Your Honor. That's correct.
All right. Just so that we make sure we don't have to come back and do this. March 27th.
Sure.
2025, 9 a.m. bond continued.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Daniel Greenwood.
And
You guys are going to have to clear that area a bit.
Good morning, Your Honor. Good to see you as always. Robert Ellman with and on behalf of Mr. Greenwood.
All right. Your name, sir?
Daniel Lowell Greenwood.
All right. I have the report dated February 20th.
Thank you.
That's what the people have as well.
Yes, Your Honor.
All right. Any other additional evidence?
Nothing for the people.
None from the defense.
All right. Do the people have a position as to what they're going to do with this, since he's not likely to obtain competency?
Your Honor, I believe we're going to be filing a Denali clause and then filing a
A petition. All right. So what I will do is I will make the finding based upon the evidence before me that the defendant is incompetent to stand trial and not likely to obtain competence within the statutory period if given treatment. I will adjourn this for the people to get everything done. I'll adjourn it out 1 month to April 3rd.
I'm sorry, Your Honor, April 3rd?
Yes, sir.
Thank you.
2025 at 9 a.m. Bond will continue at this time. Thank you.
Thank you, Your Honor. Have a great day.
You do the same. Court does call the case of the People versus Neil Hines.
I didn't hear you, Judge. That might be.
No.
BAG's in.
Yes.
Good morning, Your Honor. Clarissa.
Thank you.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Morning, Your Honor. Assistant Public Defender Cosimo Bass on behalf of Neil. Have you stated your claim for the record, sir?
Neil Hines.
All right.
What are we? Your Honor, previously there was an offer from my client to plead to a disorderly person if he paid up amount in the arrearage. I believe that amount has been paid up. Is that offer still extended by the AG's office?
Yes, it is.
So, Your Honor, my client wants to.
I'm going to do some paperwork because I don't.
Can we briefly pass this matter?
I'll pass the matter.
Thank you, Your Honor.
Court recalls the case of the People versus James Sharp.
Morning again, Your Honor. Raymond Cook for the people.
Ready, Your Honor. Good morning, Your Honor. James Fifelski appearing on behalf of James Sharp.
Mr. Sharp, can you state your name, please?
James Glenn Sharp.
Thank you.
Your Honor, we are asking for an adjournment for additional discovery. Mr. Cook is working on gathering videos and additional records for us. So I'm hoping the court could set this out just 2 weeks.
Without objection, March 20th, 2025, 9 a.m. bond continued.
Thank you, Your Honor.
Thank you. Thank you, Mr. Sharp.
Yes, sir. Thank you.
Take care, Mr. Sharp.
Court calls the case of the People versus Dantes Cheney Field.
Morning, Your Honor. Sorry. Good morning,
Go
Your
ahead.
Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Assistant Public Defender Asa Bashir here with and on behalf of Dentes Cheneyfield. Mr. Cheneyfield, please say your name.
Dantez Cheneyfield.
Thank you.
How you doing?
What are we doing?
All right, today we are, Mr. Cheneyfield would like to waive his preliminary exam and proceed to circuit court.
Is that correct, Mr. Chainfield?
Sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Your turn.
Oh, sorry.
You acknowledge receipt of the information waiver to reading?
Yes.
And how does your client plead?
Not
Standing mute.
Standing mute, yes.
Defendant having waived former reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for 17/2025, 1:30 before Judge Hamoud.
Thank you, Your Honor.
Bond will continue. Thank you. Court calls case People versus Cody Lee Jolly.
I'm sure there's a praying on behalf of people.
Mr. Jolly.
Jolly, you're on in front of the judge.
Mr. Jolly. Is not responding. What are the people intending on doing this? He was found competent. I mean,
He was found competent.
Yes.
Yeah, I thought you said incompetent. Sorry.
No.
That's the tenor of my voice. What I can communicate, Your Honor, Mr. Jolly also has a case pending in the 15th District Court.
So you want me to send this here? But no, go ahead. I'm sorry.
And I believe I was speaking with the prosecutor handling that case earlier this week. I think the intention is potentially to file a petition in both cases.
Got it.
Mr. Jolly. So why don't we kick this out a couple of weeks and I'll see if I can have that done by then, because I'm kind of at a loss of what else to do.
What else to do with it? Because he's not responding, didn't come up, and Joe has been kind enough to provide video for it. So what I will do, you think a couple of weeks you'll be able to do it? Or?
I expect to be in trial the 20th. Could we come back on the 27th?
March 27th, 2025, 9 a.m. during the probable cause. Bond continue. Thank you. Court does call the case of the People versus David Furman, AGA case.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Morning, Your Honor. Edward Lucas on behalf of David Furman, who is appearing by Zoom.
Sir, can you please state your name?
David Lee Furman.
All right.
Your Honor, we're basically at a resolution in this case. I do need an adjournment to finalize it. We need to apply some bond money to some back support, but there should be a zero balance point here shortly. I think there is a zero balance right now. We just got to work out an offer.
Okay. Can you do that in 2 weeks?
We could do that in 2 weeks.
Without objection, probable cause conference will be adjourned March 20th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Fabian Herrera.
There's appearing on behalf of the people.
Good morning, Your Honor. James Fifelska appearing on behalf of Mr. Herrera, who is approaching. Please state your name.
Your Honor, my name is Fabian Herrera.
I think this is an AG, right? Huh?
Come on, Your Honor.
Is it? Oh, okay. I'm sorry.
Your Honor, we're just asking the court to set this for a preliminary exam at the next available date.
Is all discovery complete?
Yes, as far as I know.
People have their witnesses available. March. People had their witnesses available March 18th.
Yes.
Preliminary examination in person, March 18th, 2025, 9 a.m. before Judge Moore.
Your Honor, may I briefly talk about bond?
Briefly.
Your Honor, my client has signed into and begun the Dawn Farm Jail program, previously filed a bond motion. I just want to reiterate that potential release on a tether, given the fact that his fiance is about to give birth probably in the next couple of weeks, and he could live with his mother, be tethered to that, or even a house arrest. He's serious about recovery as well as handling all of his court obligations. So I would ask.
I addressed his bond, didn't I?
You denied bond before.
And I denied your request.
And I'm just asking reconsideration.
Since then?
That he's in the Dawn Farm Jail program.
Has he completed it?
Not yet, Your Honor.
Anything else?
Nothing else.
Motion for bond reduction denied. Bond will continue.
Thank you, Your Honor.
Court calls the case, People versus James Belleville.
Edward Drugas on behalf of James Belleville.
Mr. Belleville, can you state your name?
James Belleville.
Your Honor, I'm finalizing a restitution payment. I believe there's been an offer I need to finalize after that restitution gets paid. I'd ask for 2 weeks.
Have we made the finding of competence?
But prior to that, there was the competency report.
Right, but has there been a?
There was a finding. I don't know, did the court not receive it?
Well, I have that finding, but has the court made the finding? I don't.
No, the court.
Yeah, because this is set for competence here.
Yeah.
Do you have any additional evidence?
No, Your Honor.
Both stipulate to the report?
Yes, Your Honor.
Based upon the report before the court would find that the defendant is competent to stand trial, specifically that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. Would you like, do you want to set out for a probable cause conference?
Yes, Your Honor.
Please. And probable cause conference will be set out March 27th, 2025, 9 a.m. Bond continued. Thank you.
Thank you, Your Honor.
Thank you, sir. Court calls the case of the People versus Tyve Mills.
Andrew Childers appearing on behalf of the people.
Hey, good morning, Your Honor. Attorney Kevin Bassant, P71061 on behalf of Mr. Tyve Mills. Mr. Mills, please state your name for the record.
Tyve Mills.
Thank you.
And Judge, just for the record, Your Honor, I did substitute in on all three of these matters very recently, Judge. I would just ask I be assigned to each case, Your Honor.
Well, you're retained?
Retained counsel, just enough.
Do I have the orders?
Well,
okay. All right, you're in.
Thank you, Judge.
So you're requesting an adjournment?
I am, Judge. Today, date and time scheduled for PCC. I need discovery in all three cases, Judge. So we're asking for a new probable cause conference.
You want 2 or 3 weeks?
Judge, can we get 3 weeks, Your Honor?
Probable cause conference will be March 27th, 2025, 9 a.m. Bond continued.
May I very briefly address bond?
Briefly.
Yeah, just very briefly, Your Honor. My client, he's 20 years old, Your Honor. He did have a prior case, but that was under HIDA. He successfully completed that. Judge, I understand these are very serious charges. The bond is $250,000 cash surety. I would ask the court to consider at the very least, Your Honor, a 10% condition with a tether, Your Honor. His family is in court. He was working prior to being arrested in this particular case, Your Honor. He would have no contact with the law, and with the tether, he can be monitored and tracked, Your Honor. So we're just asking for a 10% provision with a tether.
Response in the people.
Your Honor, the defendant was charged in, I believe it's 25 F10203, among other things, possession with intent to deliver meth, felony firearm. The defendant was producing Glock switches using a 3D printer as well as ghost guns. When the police went to arrest him on that warrant last week, he attempted to flee, crashed into a MSP trooper, was involved in a chase with Pittsfield police. When they eventually apprehended him, he was again found in possession of a firearm. During that chase, subsequently searched his home and found more with, I guess you would call molds in producing these ghost guns, as well as suspected controlled substances. So obviously, he's not only a danger to the community, but also a flight risk. I'd ask that bond remain as currently set.
Anything further, Counsel?
Nothing from defense counsel. Your Honor.
Motion for bond reduction is denied. The court does consider the defendant a danger to the community and certainly a flight risk also. Bonds will continue in each of these cases.
Thank you very much, Your Honor.
Court does call the cases of the people versus Samantha Warren.
Andrew Childers, appearing on the
Edward Druckesampe, Samantha Warren.
Private First Class Samantha Warren.
Thank you.
Your Honor, there's some negotiations that are still going on. I'm asking for an adjournment in this case. In all 4 cases.
How much time did you need?
At least 2 weeks, whatever the court's preference is.
March 27, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court does call the cases of the people versus Jeffrey Stoops.
Alexander on behalf of the people.
And Edward Drucas on behalf of Jeffrey Stoops in the 1740 matter.
And good morning, Your Honor. Assistant Public Defender Shanazay Perry Akinrui on behalf of Jeffrey Stoops on the 1740 matter.
Good morning. My name is Jeffrey Allen Stoops.
In the 1740 matter, I'm looking to obtain video in situation, so I'm asking for an adjournment.
And Your Honor, in my matter, we would be requesting an adjournment. We want to see if he would be eligible for a recovery court.
Probable cause conference in these matters, March 27, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you. Court does call the case of the people versus Elizabeth Black.
Alexander on behalf of the people.
And good morning, Your Honor. For the record, Brendan Dvorsky appearing on behalf of Elizabeth Black, who's standing at the podium to my right. Ms. Black, please state your name for the record.
Elizabeth Black.
Your Honor, today's date and time set for a probable cause conference. I was just retained on this matter this week. I filed this substitution of counsel yesterday. Spoke to the prosecutor today. We're just asking for an adjourned probable cause conference. I've explained to my client the 14-day rule, and she is voluntarily waiving that. Is that correct, ma'am?
Yes.
March 27, 2025, 9 a.m.
Your Honor, I'm going to be out of town that day. Is it unless it's possible I can do it via Zoom, but if not, can we have the 3rd? Is that available?
April 3rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. We're all set.
Court calls the case of the people versus Shane Young.
Alexander on behalf of the people.
Morning again, Your Honor. May it please the Son of the Court. David Burgess on behalf of Shane Young, who's approaching via wheelchair. Let's break him out. He's already in the chair. Just state your name, Shane.
Shane Allen Young, 3183.
Discovery is complete in the matter requesting exam date, Your Honor.
We will have their witnesses available the 18th.
We'll do our best, Your Honor.
Preliminary examination in person will be set March 18th, 2025, 9 a.m. That is before Judge Barr. Bond will continue.
Thank you. Chime in. Take care.
Court does call the case of the people versus Shala Gilden.
And then on behalf of the people.
What are we doing with
I'm sorry.
Gilden?
Yes, yes.
Sir?
Coming back in.
We can't have these facilities waiting. What are we doing?
Good morning, Your Honor. Sydney Rushing, appearing on behalf of Ms. Gilden, who's approaching my right. Your Honor, I apologize, she was in the hall because the courtroom was full. Can you state your name for the record, please? I'm Shayla Gilden. Thank you.
You take your hands out of your pockets. What are we doing?
Your Honor, at this time, we'd like to schedule this matter for a preliminary examination.
All discoveries complete.
Yes, Your Honor.
People have their witnesses available the 18th.
We'll do our best, Your Honor.
Preliminary examination in person will be set March 18th, 2025, 9 a.m. That is before Judge Moore. Bond will continue.
Thank you so much, Your Honor.
Thank you. Court does call the cases of the people versus Rebecca Elledge.
Morning, Your Honor.
And good morning, Your Honor. Sydney Rushing, appearing on behalf of Ms. Elledge, who is approaching to my right. Ms. Elledge, can you state your name for the record? Loud and clear, please.
Thank you.
Your Honor, at this time, we'd like to set this matter for a preliminary examination.
Cases.
Yes, Your Honor, and discovery is complete.
People have their witnesses available the 18th.
Yes, Your Honor.
Preliminary examination, March 18th, 2025, 9 a.m. That is before Judge Barr. Bond will continue in these cases.
Thank you so much, Your Honor.
Thank you. Court does call the case of the people versus DeBrera. Collier. You know who I'm talking about.
Andrew Childers appearing on behalf of the people.
Kyle Verdell on behalf of Ms. Deborah Collier. Good morning, Judge.
Thank you. Ma'am, state your name.
Deborah Collier.
Thank you. She's waiving right to preliminary examination.
That's correct, Judge. We are, there should be a waiver form in your file.
I've got it in file. Ma'am, is that correct?
Yes.
And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was, or the offense is, well, the offense alleged was committed and that you committed it. You understand that?
Yes.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Defendants bound over to circuit court in this matter.
Thank you, Judge. Nothing.
Your turn.
Sorry, Judge.
Do you waive formal reading?
Yes, Judge.
Does your client stand mute?
Yes, Judge.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial in this matter will be set for.
26 at 1:30 before Judge Collins. Your Honor, my microphones are not working.
Oh,
I'm
now they're on now. Are you picking it up?
Is this?
What was that date, Your Honor? Sorry.
March 26th. And that's Conlon.
Yes.
All right. We'll repeat it on the record, but she doesn't have to wait. Ma'am, you can hear me?
Yes.
Okay. March 27th, 2025, 9 a.m. For Judge Conlon. Bond continued in this matter. Court will stand in recess while we try to get this. So that's fine. I'll just deal with it. Before the system went down, I was on the Collier matter, just so that the record is clear. She waived preliminary examination. It was bound over to circuit court. So also the record's clear. She could hear me and I double checked that she answered all the questions appropriately. And it's set for the 25th, wasn't it? March 26, 2025 at 9 a.m. 1:30 before Judge Conlon. That's what I meant to say. Thank you. Court does call the case, People versus Eddie Gardner. Stay on the way.
Andrew Childers appearing on behalf of.
Oh,
Good morning, Your Honor.
oh,
You had to deal with me at some point today. You knew.
no, I really, but I will.
Great. Christina Costantino appearing on behalf of Mr. Eddie Gardner, who is approaching. Eddie, can you please state your name for the record?
Eddie Gardner.
Thank you. All right. What are we doing on this?
Judge, this is a date and time set for a PCC. At this time, we would be asking for a 3-week adjournment of the PCC to obtain all the necessary discovery.
In both cases?
Yes, Judge, that is my understanding. Is that your understanding, Mr. Childers?
Oh, he's got the new case and then.
The new case is we would be adjourning for discovery. The previous case is,
An issue.
yes.
And I think we will have a resolution, well, a disposition on that case on our next date.
So you want me to put them both over to the 27th?
Yes,
You
Judge.
realize it's, okay.
Yes.
Isn't this the one you had me move to today?
Yes, Judge. I just wanted them kept together.
Because we already had it, you know.
Well, it would have been the
No,
20.
I don't-
Keep them together.
No, she had us move it.
Judicial efficiency.
This was not efficient.
Well, now they'll be together. You won't see us twice, back to back.
That's at least one good thing. Probable cause conference in these cases, March 27, 2025, 9 a.m. Bond will continue.
Thank you, Judge.
Court calls the case of the people versus Jerry Bigham.
Ashalani for the people.
Hi, Overdell, on behalf of Mr. Bickham. Mr. Bickham, please say your name for the court.
Jerry Bigham.
So, Your Honor, today's date and time set for probable cause conference. We have received video. I just haven't had time to review it yet. So we're asking for one final adjournment. This will be the last adjournment. We're asking for 2 weeks.
Probable cause conference, March 20th, 2025, 9 a.m. without objection. Bond continue.
Thank you.
Court calls the case of the people versus Jeffrey McCullough.
Raymond Cook for the people.
Christopher Quinn appearing on behalf of Mr. McCullough.
Oh. Apologize, Mr. Quinn. Laura Yagi, Assistant Public Defender with and on behalf of Mr. McCullough. Sorry. In the case ending in
5611.
yes. Thank you, Your Honor.
5631. All right. All right, what are we doing on these cases, folks?
Well, Your Honor, I would to increase Mr. McCullough's bond. Actually, he's sitting on a personal bond. In terms of the substance of what we're doing today, I would also ask for a very brief adjournment. I spoke with the APA, and we are trying to work towards a global resolution here. Mr. McCullough is being held on another matter until he's allowed to be released to treatment, but until June is his estimated release date. So he's sitting on a personal bond in this case. So I would ask if the court would consider increasing his bond so that he could potentially earn some credit.
Quinn, what are we doing on your case?
It was my impression that Mr. McCullough was getting new counsel. Is that not the case?
Not the case currently this time.
Okay,
Was
well, I
unable to do so.
don't have a problem with the brief adjournment, Judge.
Probable cause conference will be adjourned March 20th, 2025, 9 a.m. And he's actually on, and Mr. Quinn, he's actually on personal on your case also. Are you requesting that his bond be increased also?
Yes, Judge.
All right. Bond in each of these cases will be set in the amount of $5,000. I'll give it 10% privilege.
5,000%.
All right. Thank you.
Thank you, Your Honor.
Court calls the case People versus D'Angelo Green.
Ashalani for the people.
Robert, on behalf of Mr. Green. Mr. Green, please introduce yourself to the court.
D'Angelo Green.
So, Your Honor, there should be a waiver, I'm sorry, an adjournment form in here. Mr. Green was given an offer. He needs a little bit of time to complete the terms of that offer. So we're asking for about 3 weeks, 3-week adjournment.
This is now like the fifth. This is the fifth adjournment on this to do this.
This should be the final adjournment.
Probable cause conference will be adjourned March 27th, 2025, 9 p.m. Bond continued.
Thank you, Judge.
I got power. Court does call the case of the people versus, is it Sequandahala Middleton? I had messed that up, but I did what I could.
Kyle Burdell on behalf of Ms. Sequangela Middleton. Ms. Middleton, please introduce yourself, unmute yourself and turn on your camera.
Sequangela Middleton.
Thank you. Your Honor, today's
I have a camera.
I'm trying to fix it. I don't know. Oh, wait.
Thank you. All right.
Thank you, Judge. Today's date and time set for probable cause conference. At this time, the people need a little more time to determine the restitution and to work on, we're working on a resolution. We're asking for a very brief adjournment. I expect we'll resolve it at that time.
March 20th, 2025, 9 a.m. Bond continued.
Thank you. I'll call you Ms. Middleton. Thank
Okay.
you.
Court calls case people versus Anthony Warren.
Ashalani for the people.
And good morning, Your Honor. Sydney Rushing, an opinion on behalf of Mr. Warren, who's approaching my right. We say name for the record.
Anthony Warren.
Thank you. Your Honor, at this time, we'd like to set this matter for a preliminary examination. The video discovery that was outstanding has been tendered, so discovery is complete.
People have their witnesses available the 18th.
Well, we will try, Your Honor. Thank you.
All right. Preliminary examination in person, March 18th, 2025, 9 a.m. before Judge Moore. Bond continued.
Thank you so much, Your Honor. Have a great day, Judge.
You do the same. Court calls case people versus Bianca Rowell.
Good morning, Your Honor. Chief Assistant Prosecutor Victoria Burton Harris appearing on behalf of the people.
On behalf of, excuse me, Ms. Bianca Rowell. Ms. Rowell, please introduce yourself to the court.
Hi, my name is Bianca Rowe.
Thank you.
Your Honor, days and times at the probable cause conference. We do need a little time to sort of gather some evidence and some documents, to talk to the people about a resolution. We're asking for a 3-week adjournment.
March 27, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Court calls case people versus Anthony Taylor.
Good morning, I'm Candy on behalf of the people.
James Feifelsky appearing with and on behalf of Mr. Taylor, who is approaching. State your name, please, for the judge.
Anthony Taylor, Your Honor.
Thank you. Your Honor, this is a first PCC. We are asking for a 2-week adjournment for further discovery and investigation in this matter.
Probable cause conference adjourned March 20th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. I'll be done. Okay, take care.
Thank you, Your Honor.
Thank you. Court calls case people versus Laura Andia.
Ashalani for the people.
Assistant Public Defender Chinazi Kyriakin, Your Honor, on behalf of Ms. Laura Andia, who is approaching.
Ms. Andrea, could you state your name for the record, please? Laura Andrea.
Your Honor, we are asking for an adjournment in this matter. We have not had an opportunity to speak with Ms. Andia previously, but we suspect that there may be some Padilla issues that we need to.
I don't.
To the actual approach.
Probable cause conference will be adjourned April 3rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case people versus Teresa Johnson.
Assistant Public Defender Jay Bellinger on behalf of Ms. Johnson, who approaches. Johnson, can you please state your name for the record?
No name Johnson.
Hello. All right. I had 3 plea forms. Is that doing or?
That is correct, Your Honor. I have the advice of rights right here. My understanding is my client's going to be pleading no contest, Your Honor. Those police reports were sent to the court.
Yes, and I reviewed those. And so starting in the case ending in 0779, the plea form indicates that the defendant will be pleading no contest to added counts 3 and 4. 3 being an attempted resisting and obstructing, 4 being an assault and battery. The first one being a 1-year offense, the other being a 93-day offense. In the case ending in 5152, plea form indicates the defendant will be pleading no contest to the charge of attempted resisting and obstructing the 1-year offense, as well as the stated count 2 of assault and battery, the 93-day offense, and count 1 would be dismissed. There's also a global agreement to 2 years probation with assessments, treatment, full restitution on all counts, even the dismissed counts. I would indicate as to the probation, I don't see that there would be an issue, but I can't bind the sentencing judges in these cases to that, but I don't see that there necessarily would be an issue regarding that. In the case ending in 5189, defendant would be pleading to the stated count 2 of assault and battery, 93-day offense, count 3, the attempted resisting and obstructing the 1-year offense, and count 1 would be dismissed along with that same global agreement. In essence, just a short of it, because there's 3 cases, Ms. Johnson, you would be pleading to 3 charges of assault and battery and 3 charges of attempted resisting and obstructing. That's the court's full understanding of the agreement.
That is our understanding as well, Your Honor.
Yes, sir.
All right. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth self you got?
Yes, sir, I do.
State your name.
Teresa Johnson.
Okay. Ma'am, it is a court's understanding that you're going to be pleading no contest to 6 charges. Is that your understanding?
Yes, sir, it is.
3 counts of assault and battery. Those are punishable by up to 93 days in jail, up to a $500 fine plus court costs. You understand that?
Yes, sir, I do.
Also, 3 counts of attempted resisting and obstructing. Those are misdemeanors punishable by up to 1 year incarceration, a $1,000 fine plus court costs. You understand that?
Yes, sir.
All right. And do you understand what a no contest plea is?
Not guilty?
No, we discussed what a no contest plea means.
Say it again.
The no contest plea means.
You may want.
Okay, thank you. The no contest.
Now, it's hard when it's your first time in the courtroom.
But the court will take it as a guilty plea, but you don't have to say anything that you do wrong. The court's going to use the police report to form a factual basis, okay?
Okay.
All right.
Okay.
Thank you, Your Honor.
Yes, made it clear.
All right. So you have a clarification now as to what a no contest plea is?
Yes, sir, I do.
All right. Tell me what you think you're doing with a no contest plea.
I don't have to plead guilty, but the court will take it as a guilty plea, but I don't have to say anything that I did right or wrong, or and what
The court's going to use the police
the
report
court's gonna use the police report
to establish
against
a
me.
factual basis.
And I'm going to assume that the information contained in that police report is true, or certainly that you're not contesting those facts.
Okay.
Understand that?
Yes, sir.
Okay. Do you have any questions regarding that part of?
You said, well, regarding that part, no, but you said you haven't found a sentencing, Your Honor, yet?
Pardon?
A sentencing judge yet? You haven't found one?
No. These cases I would be taking. Okay. That's
Okay.
an important part for you to understand. So I need you to understand this about a no contest plea. Let's go back to,
Okay.
and hopefully when I get through things, it will all answer for you. But
Thank you.
the no contest plea means that you're no longer wanting or desirous to contest these 6 charges. You understand that?
Yes. Can you
All right.
repeat what the 6 charges are again, please? Now you don't have to go in depth
No,
about
no,
it. Just
that's
give me the
okay.
title.
That's okay. If you don't hear something or understand it, I have to make sure that you do.
Okay, thank you now.
There are 3 charges of assault and battery.
Yes, sir.
Misdemeanors punishable by up to 93 days in jail, $500 fine plus court costs.
Okay,
Okay?
yes.
There are 3 charges of attempted resisting and obstructing a police officer, or yes, attempted resisting and obstructing a police officer.
Sorry.
Those are misdemeanors punishable by up to 1 year incarceration
Okay,
and a $1,000 fine plus court costs.
okay,
Okay?
yes.
It's the court's understanding you're pleading no contest to those charges.
Okay, so if I wanted to pay them off, I couldn't do that either? Can I?
Wanted to pay.
Pay
them
the
off.
like $1,000 for the resisting and
Okay.
obstructing a police
So-
officer?
All right.
No, okay.
That's the maximum fine.
Okay,
Okay? That's not a dollar amount that you could pay and just be done.
okay,
Okay? You understand that?
I believe so.
Well, I have to make sure that you understand.
Yes,
Ms. Johnson, listen. If you're not understanding,
No.
then I'm not going to take your plea.
I
So,
understand.
no, just listen.
Okay.
And it's not, I'm not mad at you about that.
Okay,
Okay?
yes, sir.
I have to make sure that you understand what you're doing. And not all of a sudden end up in a circumstance where
Yeah,
you didn't understand why you did something or whatever.
okay,
The other part of, just so that you know, a no contest plea is that for the purposes of sentencing, the respective courts are going to treat you the same as though you had pled guilty to these charges.
okay.
Understand that part?
Yes, sir.
Okay. Now you understand also that, I almost hate saying it, but I'm going to say it. There's an agreement between counsel that you'll be placed on probation. But because I'm not the sentencing judge in these cases.
Okay, I wish you were.
Huh?
I wish you were.
You know, I don't get that a lot. Thank you.
You're welcome.
But because I'm not the sentencing judge,
Okay,
I can't bind the sentencing judges to this agreement.
okay,
So that while that's an agreement, and from my perspective and experience, I don't see that there'd be a problem with it. They may decide something different.
okay.
You understand that?
Yes, you're not the sentencing judge, but can't make the decision based off what they might say, and they might find something different.
Yeah, they may not go along with that agreement.
Okay,
You got that?
There's no real reason to believe
Ms.
that they
Johnson,
won't. like you
Ms.
said.
Johnson, listen.
okay,
And I'm gonna make the ultimate determination, but would you want to talk with your attorney a little bit more just to make sure and be clear about what you're doing?
yes, please. I would desire that.
Okay, all right. And Ms. Johnson, that's fair,
Okay,
right? Because I want to make sure I'm explaining it, but I want somebody that's on your side to also kind of go through it with,
okay.
kind of understand it.
You're doing a great job. I'm just a little slow.
I've done a
So-
great job.
You're doing a great job. at
Yeah, say
explaining
that
it.
louder.
Okay, you're doing,
No,
you're doing a great job.
Hey, thanks. All right.
Your Honor, may counsel briefly,
Nothing like fishing for compliments.
Okay.
Go ahead.
may counsel briefly approach?
You may.
Okay, thank you.
Be right back.
All righty.
Okay.
Yes, sir.
And then give you an opportunity to speak with your attorney. I'll probably speak with you certainly before that date, but then he'll speak with you on the date of that.
Okay.
Okay. So that we can then make sure that you understand everything.
Okay, yes, sir.
Okay.
Thank
And
you.
just so that you know, you're not in any trouble or anything like that
Okay.
for asking the question.
Thank you.
You know,
Appreciate that.
I have to make sure that you understand, and I'll, you know, that everything's answered for you before you
Yes,
do.
sir.
All right.
You're doing a great job, Simpson.
Thank you. Thank you, Mr. All right.
All right.
I'll adjourn these
We'll
to
talk
the
soon.
20th.
Okay,
Take
thank
care.
you.
All right, thank you. Court does call the case, People versus Neil Hines. Yes, I do. Go ahead, Madam Prosecutor, if you can put your appearance on the record.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Thank you.
Thank you. Good morning, Your Honor. Assistant Public Defender Constable Bates on behalf of Neil Hines, who is present to my right. You state your full name for the record, please,
Morning,
sir.
Your Honor, Neil Hines.
All right. I have before me a plea form that indicates that the defendant will be pleading to the charge of disorderly person. Is that a 90-day 100 or 90-day 500?
I believe it's 100, if I'm correct.
All right. I'll just do it that way. 90 days, 500 or $100 fine plus court costs. You understand that, sir?
Yes, sir.
All right. And that the defendant then, after his guilty plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement. Is that correct, counsel?
Yes, Your Honor.
Yes, Your Honor.
All right. Thank you. May I have the defendant sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Neil Hines.
All right. Sir, it is this court's understanding you're going to plead guilty to the charge of disorderly person. That's a misdemeanor punishable by up to 90 days and or $100 fine plus court costs. You understand that?
Yes, sir.
Understanding that, you
Yes.
still wish to plead guilty?
Yes.
Well, I do also advise you that while I wouldn't be your sentencing judge, while I'm taking your plea, I wouldn't be your sentencing judge, and you would be sentenced before Judge Ferry. Judge Ferry. Is anybody gonna have an objection if I immediately sentence?
No, Your Honor.
No, Your Honor.
All right. So, sir, to that charge, how do you plead?
Guilty.
Now, you understand by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
All right. You had signed an advice of rights form.
Yes.
Any question regarding those rights?
No, sir.
Please look at paragraph 5. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of.
Yes.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, I'm not.
Has anybody promised you anything other than what's been stated here today on the record?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes, sir.
All right. We're gonna have to do this a little bit differently. On the date. What date's here? It's gonna be a little bit difficult to do, but let's do it this way. During the course of the year 2024, right, sir? You failed to
Yes.
pay child support.
Yes, sir.
Is that correct?
Yes.
All right. While that has now been taken care of, you would agree that, well, you failed to pay child support, right? All right. Counsel, I'll do it this way, just because it's a bit unusual. Without objection, I would accept his plea to the higher charge. Or I would accept his plea to the lower charge, having admitted the higher charge. Is there any objection to the court following that procedure?
No objection at this time, Your Honor.
No, Your Honor.
All right. Court will accept it. Has the court complied with the court rule in that regard, and would it be proper to accept this defendant's plea?
The defense is satisfied.
Yes, Your Honor, it's appropriate.
Thank you. Court will accept the defendant's guilty plea to count 2. Count 1 is dismissed. Sir, is there anything you want to say before I impose sentence?
No, I appreciate it, sir.
Fines and costs of $250. When can you pay that?
2 weeks.
2 weeks. All right. Pay it by March 31st, 2025. You'll have to pay it at the 15th District Court.
I can pay it online as
In
well.
downtown Ann Arbor.
Can I pay it online as well?
I'm not sure what their system is, but you probably can once they have it in there. All right. And I'll suspend 90 days in jail.
Thank you.
All right. Thank you.
Thank you, Your Honor.
Court does call the case People versus Johnny Bankhead Williams.
And on behalf of the people. Stephanie Shannon on behalf of the Bankhead Williams, who is the train.
You're requesting an adjournment.
Yes, Your Honor, I'm requesting a 2-week adjournment. I did ask for a lot of, I believe this is the case where I emailed for a lot of discovery in this case. And it's also my understanding that DNA is going to be necessary. I'm sorry, are you?
Different here.
Oh, no, Your Honor, I just emailed for discovery.
March 20th, 2025, 9 a.m. Bond will continue.
Your Honor, could you entertain client?
Pardon?
Would you be willing to entertain tethering for my client to his home address? No?
You're making a bond request?
Yes, Your Honor. You hit the thing really quickly. You went quick. You went quick. You said everything really quick.
Well, make your argument.
Thank you. Your Honor, in this case, my client actually does not live in this area. He lives in the Detroit area. He has no desire to be anywhere near the address where this incident occurred. He can be tethered to the Detroit home, ensuring that the complaining witness will not have any experiences with him during that time frame, and he's asking for that opportunity.
Your Honor, people be opposed to any modification of bond. In this case, the defendant had been trespassed with the residence and returned and tried to break into the residence. He broke her storm door trying to get in and only stopped when he saw police. He was found with a knife in his pocket and the residence and hiding under the bed scared university. He also has a previous history of a conviction for felony firearms and an armed robbery in 2017. I had great concern for her safety, given that he had already been trespassed from that residence and went back to that residence.
Anything else?
Your Honor, he could have, they were having contact with her consent. So when he did go back, he had something at the house. He just wanted it back because he had been there previously, Your Honor.
Motion for bond reduction denied. Bond will.
Thank you.
Court calls the case People versus Marquise Babb.
Alexander, on behalf of the people, Your Honor.
Assistant Public Defender, on behalf of Mr. Babb. Mr. Babb, could you state your name for the record once you reach the podium?
Your name?
Oh, Marquise Babb, how you doing today?
Doing great. How you doing? All right.
Judge, you're requesting an adjournment in this matter.
Probable cause conference will be adjourned March 20th, 2025. 9 a.m. Bond continued.
Thank you, Judge.
Thank you. Thank you, sir. Yeah, you do it. Sounds like I knew you were greedy. Court calls the case People versus Michael Campbell.
Good morning, Your Honor. Victoria Burton here. Prosecutor appearing on behalf of the court.
All right.
Good morning, Your Honor. Assistant Public Defender Qasim Baldesi on behalf of Mr. Michael Campbell, who is present to my right. Michael, can you state your full name for the record, please?
Michael Campbell.
You're requesting an adjournment?
No, Your Honor. We are now waiving the exam. I have a new form for you.
Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were you committed them?
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on all 4 counts.
Your Honor, may I address bond briefly?
Yeah, go ahead.
Your Honor, my client is going to be
You want to
requesting.
do the circuit court arraignment or you want to address?
Oh, I'm sorry. Yes, we could do the
Yeah, I
circuit
know.
court.
You didn't follow the rules. Go ahead.
At this time, we'd waive formal readings and stand mute to the charges.
Defendant every way formal reading standing mute. Court will enter a not guilty plea as to all counts. Pretrial will be set for
March 19th at 1:30 p.m. with Judge Conlon.
March 19, 2025, 1:30 before Judge Conlon. As to bond.
Yes, Your Honor, my client is requesting a PR bond while he awaits his circuit court pretrial. He's a lifelong resident of Ypsilanti. He has an 8-year-old son that he provides. He has a job at E.B. Brown awaiting for him. As to the allegations in the police report, there were no But my client didn't threaten anybody. There was no violent actions on his behalf. So we would just ask for a PR bond in this matter, Your Honor.
Response from the people.
Your Honor, the fact that he was at a golf apartment complex, drunk, waving a gun around or having a gun in his possession, to me suggests that he was absolutely posing as a threat. Being drunk with a firearm in the middle of an apartment complex, with the gun history and drug history that he has, I would ask that the bond stay exactly as it is, because I think it's appropriate both for community safety purposes and so that we can ensure he will remain with us and allow us to continue this prosecution successfully.
Anything else?
Yeah, Your Honor, I would just say that the alleged firearm was already seized. My client's already been in jail for 10 days now.
Motion for bond reduction is denied. Bond will continue. Thank you. Court calls case People versus Cameroon Brown.
Morning, Your Honor, Ray of the People.
Assistant Public Defender Counsel Relays on behalf of Mr. Brown. Will you state your photo for the record, please, Tom?
Brown.
Thank you.
Your Honor, requesting an adjournment at this time. There are still negotiations going on.
Probable cause conference will be adjourned March 20th, 2025, 9 a.m. Bond continues. Court does call the case of the People versus Mario Crawford.
Morning, Your Honor, Ray of the People.
Morning, Your Honor. Brian Bowling on behalf of Mr. Crawford. State your name. Judge, we have a resolution that's memorialized on a plea form before this court, and Mr. Crawford would like to take advantage of that today and plead no contest pursuant to that agreement.
And in this other case, is that taken care of on this or no?
Are you talking about, all the felonies are being resolved as part of that
So
plea?
Case 1459 will be dismissed
That's correct.
in its entirety.
Yeah, and he's pleading to 2 counts of attempted assault, resist, obstruct a police officer under the 55, or he's pleading no contest to fit under 5551, Judge, for lack of memory.
The plea form indicates that the defendant would be pleading to added counts 3 and 4, attempted resisting and obstructing the 1-year offenses. Upon a successful plea of no contest to that charge, counts 1 and 2 in case 5551 would be dismissed, as well as 22F2 1459 would be dismissed. That's the court's full understanding. Is that correct, counsel?
Yes, Your Honor.
That is correct, Judge.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
All right, Crawford.
Sir, it is this court's understanding that you're going to be pleading no contest to 2 charges of attempted resisting and obstructing a police officer. Those are misdemeanors punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes, sir.
All right. You also do you understand what a no contest plea is, sir?
Yes, sir.
All right. 2 things about it. I have to make sure that you understand it. First means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
I also have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th.
Yes, sir.
Understanding all of that, you still wish to plead no contest?
Yes, sir.
To the charge of attempted resisting and obstructing a police officer contained in count 3, how do you plead?
No contest.
To that same charge as contained in count 4, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
All right. You signed an advice of rights form?
Yes, sir.
Any questions regarding those rights?
No, sir.
Look at paragraph 5. See one on the podium. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that.
Correct, sir.
You understand you're giving up the right to appeal of rights.
Yes, sir.
Are you on probation or parole?
No, sir.
Anybody promise you anything other than what's been stated here today on the record?
No, sir.
Anybody threaten you or coerce you?
No, sir.
Doing this voluntarily?
Yes, sir.
and of your own free will.
Yes, sir.
All right, the court has been provided and has reviewed Ann Arbor Police Department report for their case number 22-312. Any objections to the court having reviewed that report?
None for the defense, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's pleas?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's pleas of no contest, 2 counts, 3 and 4, counts 1 and 2, as well as case ending in 1459 are dismissed pursuant to that plea agreement. Pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing in this matter will be
March 28th at 10 a.m.
I'm sorry, March 28th, 2025, 10 a.m. before judge. Bond will continue.
Thank you, Judge.
Court calls the case of the People versus Sheldon Brummett.
Good morning, Your Honor. Chief Assistant Prosecutor Victoria Burton Harris appearing on behalf of the people.
Brian Bowling on behalf of Mr. Brummett. State your name for the rest.
Sheldon Brummett.
You're requesting an adjournment.
Yes, please, Your Honor. He's close to having the fun together, hiring an attorney. Right? Just
Well, didn't we adjourn it for that purpose already?
we did.
I told you at that time, I'm not adjourning it for that purpose again. We need to go forward on this case.
So just, I guess funded over because I thought I was getting out of jail and I stayed in jail longer, so I couldn't.
So you want to wait for the exam? Or do you want to set an exam? Will you pass the case, Judge? Let me speak to him. Thank you, Judge.
Court calls case of the People versus Van Davis.
Your Honor, Ray Cook for the people.
Told you back.
I know, you told me you'd be back. Yeah. Welcome back.
Hey, well, nice to be here.
Assistant Public Defender Asif Bashir here with and on behalf of Man Davis. Mr. Davis, you can.
Man Davis here once again.
Yes, I know.
It's always nice seeing you.
Well, and you, Mr.
Thank
Davis.
you.
All right.
To our knowledge, discovery is complete. We would like to request the earliest possible preliminary exam date.
I got it. Preliminary examination, and would the people have their witnesses available the 18th?
Yes, Your Honor.
Preliminary examination in person, March 18th, 2025. Before Judge Moore. Bond will continue.
Thank you, Your Honor.
Davis, take care. You're not coming back anytime soon, are you?
I'm thinking about it.
All right.
I'll let you know.
Okay. Court calls the case, People versus Kevin Bird.
Ashalani for the people.
Your Honor, Alexis, my Assistant Public Defender with and on behalf of Mr. Burden. Mr. Burden, could you state your full name?
Kevin Burton, Your Honor.
Thank you.
And Your Honor, we are requesting a brief adjournment here. I would ask for 2 weeks.
March 20th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Excuse me, sir.
Court calls the case, People versus Clinton Douglas Jr.
Alexander on behalf of the people.
Stephanie Cannon on behalf of Mr. Douglas, who is seated to my right. Mr. Douglas, could you please state your name for the record?
Clinton Douglas Jr.
Thank you.
Your Honor, my client is asking for his preliminary exam.
Is discovery complete?
Yes, Your Honor.
People have their witnesses available the 18th.
We'll do our best, Your Honor.
Your Honor, if I could address Baran.
Briefly.
Thank you, Your Honor. My client is, as you can see, he's in a wheelchair. He has little to no use of it. Is it your right knee or left knee? His right knee, Your Honor. Right now, they have him in max security because they can't put him on any other floor, I'm being told by my client at least, because he cannot navigate the stairs whatsoever. I understand that my client did not appear for court, Your Honor. In that case, the mailing address was his daughter's, and she told him the day after. My client didn't learn about it till the day after, but he wanted me to let the court know he just had a series of medical appointments because, again, his leg is not usable. And so he was just trying to get all of that taken care of. He has assured me, and I let him know, and he has to understand that when the court says he has to be here, he has to be here regardless of what's going on with his legs. Your Honor, he's just asking if you would be inclined to either tether him to the house and just allow him to do his medical appointments, but he'll be back when the court requires him to be back. Thank you, Your Honor.
I don't need a response. He knew he had to be here. There's been written, he's been told at various proceedings to be here. And he didn't appear, so I don't understand what the mailing issue is. He was given the date, and certainly he's had counsel who would have also provided the date to him. So that's not a justification for it. I'll set preliminary examination, March 18, 2025, 9 a.m. before Judge Barr.
I'm sorry, Your Honor, what was that date again?
March 18th.
3/18. Thank you, Your Honor.
Before Judge Barr. Motion for bond reductions denied. Bond will continue.
Thank you.
Court calls case People versus Nathan Burns.
Official is appearing on behalf of the people.
And Assistant Public Defender.
Your Honor, Ashley Lonnie for the people. I apologize, Your Honor. Could we pass this for one moment, please?
Yes, I'll pass it. Court calls the case of People versus Portia Elledge.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Chelsea Vergils with and on behalf of Portia Elledge. Ms. Elledge, please state your name.
Portia Elledge.
What are we doing?
Your Honor, Ms. Elledge would waive her right to a preliminary examination.
Is that correct?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution?
Yes.
People also waive the right.
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
We acknowledge receipt of the information, waive a formal reading, and stand mute.
Defendant every way formal reading standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
March 20th at 1:30 before Judge Slay.
March 20th, 2025, 1:30, Judge Slay. Bond will continue.
Thank you, Your Honor.
Court calls case People versus Brandon Carter.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Brandon Carter.
Is he here?
Brandon Carter. Then I have.
You sure could. I'm sorry.
We got you. Your Honor, I have paged the courtroom for Mr. Carter. I have received no response. I do note that the contact number we have for him is not in service at this time. we have no explanation for his absence at this time. However, then we are sure that he will show up if you give him a new court date. Based on that, we're asking for an adjournment, and we'll see if he shows up. Oh, I forgot.
Wow.
I put one out for Mr. Brown.
Yeah, I did. I do. I see it. It's not. Bank will issue for defendant's failure to appear, bond 10,000, cash surety. Those warrants, please show me these. Thank you. So nicely done. Although only unusual. Court calls the case People versus Alton Ford.
Ashley Lonnie for the people.
Case, never mind, it's over here.
All right. Your name, sir?
Alton Ford.
Yes.
I chose 11:18.
Well, where is he?
He's
Is he in Zoom? Sir, have you hired Mr. Dox?
Yes, I did, but I don't know what's going on.
Me either. Because he appeared at your arraignment,
Right?
right? And then I don't know what happened. I didn't get some bizarre substitution of attorney, but the PD was never on the case. And Ms. Yagi signed it, but really shouldn't have signed it because I didn't accept it, and I did not sign off on a substitution. We then told him that he needed, because you were in custody, he needed to be here, and that he needed to file an appearance, which would be the proper way to do it. And he's not here. He wanted to appear via Zoom. I did not approve that because you were in custody, and I felt you probably wanted to talk to him. That was my feeling.
And Your Honor, for the record, I have not had any direct communication from Mr. Dox regarding this case.
So, sir, so that you have representation at this point, the PD will represent you initially, okay? Because I'm not sure what's going on myself, so I just want to make sure that somebody's talking to you about what the case is about. Fair enough?
That's fair.
All right. So I don't know what I'm going to do with this appearance. I'll tell you what. You can tell Mr. Dox the court is not accepting his appearance. And that when he decides that he wants to bring himself to the court and talk to his client, the court will accept his appearance. This is a public defender case. Thank you, Mr. Brown.
Thank you, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Ford. Your Honor, today is the date and time set for the probable cause conference. We have not reviewed the discovery. We'd ask for a 2-week adjournment to be allowed to do that.
Probable cause in this case will be adjourned March 20th, 2025, 9 a.m. His bond at this time will continue. All right. Thank you, Mr. Ford. Court calls case People versus Sean Cotton.
Morning, I'm Raymond Cook for the people.
Defender Chelsea Vergils on behalf of Sean Cotton. Your Honor, I received an email early this morning from Mr. Cotton who informed me that he is at the Henry Ford Hospital in Detroit. I believe he had to have an emergency surgery. I would ask for an adjournment in this case. I do have intake paperwork that he signed today for Henry Ford.
You have paperwork from Henry Ford?
Yes, can I?
Oh. Grant the adjournment request. And probable cause conference will be adjourned March 20th, 2000. Well, let's make it March 27th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus John Fulton.
Good morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Fulton, who's standing to my right.
Hello. Hello. Your name?
John Fulton.
Thank you.
Your Honor, I would be asking for a 1-month adjournment. I did make a referral to our AIM division, and I think it's really important there's some social work intervention. I think that's going to be crucial to.
When did we? He was here yesterday, but I'm not sure what date we adjourned this.
Well,
let me see.
Yesterday you adjourned, you had me on for, out of Pittsfield Township for. No, go ahead.
No, that's okay. I don't mean to
For-
interrupt.
For a traffic ticket.
That's right.
Right.
And I think it was adjourned, Your Honor, to the March 19th.
Okay, but this is obviously a more pressing issue, so.
Sorry.
All right, you wanted a month out?
I think that's what, I actually asked social work this morning if they thought a month was a good time frame. I haven't heard back, but I think it's probably safe to assume that
They're gonna
maybe-
take as long as they possibly can. They understand no urgency in it. No, I'm kidding. You can let them know I said that. Probable cause conference will be adjourned to April 3rd,
Thank you, Your Honor.
2025 at time. Bond in this matter will continue.
Thank you.
Court calls case Beaver versus Tim Crawford.
Stephen Crawford?
Right here.
No, I know you are.
Oh.
Assistant Public Defender Jay Bellinger on behalf of Mr. Crawford, who stands to my right. Mr. Crawford, can you please state your name for the record?
Stephen Crawford.
All right, I have a plea form that indicates that the defendant will be pleading guilty to 2 charges: attempted resisting and obstructing a police officer's account 4, the 1-year offense, and account 5, operating while visibly impaired, the 93-day offense. Upon a successful guilty plea to those charges, counts 1, 2, and 3 would be dismissed. That's the court's full understanding. Is that correct, counsel?
That is correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Stephen Crawford.
All right, Mr. Crawford, is this court's understanding that you're going to be pleading guilty to 2 misdemeanor charges? Is that correct?
Yes, sir.
All right, the first charge is that of attempted resisting and obstructing. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes, sir.
The second charge is that of operating while visibly impaired. That's a misdemeanor punishable by up to 93 days in jail and $300 fine plus court costs. The court could order any community service or rehabilitative services the court deems necessary. Court could also order your vehicle immobilized, could order your vehicle forfeited, could also order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, sir.
All right. Understanding all of that, well, and I also do have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Moore in the 15th District Court. You understand that?
Yes, sir.
All right. Still wish to plead guilty?
Yes.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
To the charge of operating while visibly impaired, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, I did.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5, and you'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yep.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
November 14th, 2024, at the location of 380 Parkland Plaza, Ann Arbor, Michigan, Scioto Township, Washtenaw County, Ann Arbor, Scioto Township, Washtenaw County, State of Michigan. Were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, sir.
What'd you have and how much?
I had a couple shots of whiskey.
All right. Were you stopped by the police?
Yes, sir.
What do you mean, yeah? Were you stopped by the police or was there an accident?
I put the car in the ditch.
Oh, so that's an accident unless you did that on purpose,
Right.
right? Accident. Police did arrive?
Yes, sir.
All right. Were you ultimately arrested?
Yes, sir.
Were you taken to the hospital or police station?
Both.
All right. At the hospital, was there a blood draw?
Yes, sir.
What were the results of that blood draw?
Your Honor, I believe that there was a combination. I believe the official results,
It was a 0.04 alcohol, but then 45 nanograms per milliliter of cocaine and some quantity of benzos as well.
All right.
stipulate to that, Your Honor.
Okay. You have no reason to dispute those results, do you, sir?
No.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol and ingestion of those?
Yes, sir.
drugs? All right. When you came into contact with the police, what happened that makes you think that you're guilty of the offense of attempted resisting arrest?
When I was detained, they put me to the ground and I got put to the ground. My foot hit him in the face. So, yeah.
Okay, so they were just putting you on the ground.
Well,
What do you do?
I was resisting.
In what way were you resisting?
I was holding my arms back and I wouldn't let them put my arms behind my back.
Because they were trying to cuff you
Yes.
and you were resisting being cuffed.
Yes.
And that's why you went to the ground.
Yes, sir.
Yeah, okay.
Defense is satisfied, Your Honor.
Court will accept the defendant's pleas guilty to counts 4 and 5. Counts 1, 2, and 3 are dismissed. I don't know why people do that. It doesn't work out well. Doesn't work. Pre-sentence investigation as well as screening and assessment is ordered at 15th District Court. Sentencing in this matter will be
March 14th at 9 a.m. before Judge Moore.
March 14th, 2025, 9 a.m. before Judge Moore. Bond with its conditions will continue.
All right.
Court calls case, People versus Devin Gawthorne.
Stephanie Can on behalf of Mr. Goffro, who is approaching, Your Honor. Mr. Goffro, when you are present, could you please state your name for the court?
My name is Devin Gothard.
What are we doing? Why do you always have a conversation once you never?
Your Honor, in this particular case, I did file paperwork for an adjournment. We're asking for a 2-week adjournment of this matter, Your Honor.
March 20th, 2025, 9 a.m. Bond continued.
Thank you.
Thanks. Court calls case People versus Gregory Davis.
Morning, Your Honor, Raymond Cook with the People.
Assistant Public Defender J. Bell on behalf of Mr. Davis, who approaches. Mr. Davis, can you please state your name for the record?
Gregory.
And Your Honor, we are,
You state your name, please.
Gregory Davis.
That gold doesn't look so bright today after the Maryland throw.
oh, come on, Your Honor.
Okay, I'm sorry. I couldn't resist. Go ahead.
At this time, we believe all discovery to be complete to the extent that we'd be asking the court to set this for preliminary examination.
People have their witnesses available the 18th.
Yes, Your Honor.
Preliminary examination in person will be set March 18th, 2025, 9 a.m. That's before Judge Moore. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you, sir.
Text
It's May.
Sounds good. All right, I have a good number.
That's true. That's maize, because we have gold.
I didn't want to.
And
correct
gold
the
is,
correct-
gold is much brighter, especially today than maize. Is that right, Mr. Allen? Thank you, sir. Court calls the case, People versus Brandon Jeevers.
Alexander, on behalf of the people, Your Honor.
Assistant Public Defender Chelsea Vergils with and on behalf of Brandon Gevers, please state your name for the record.
Brandon Jeevers. Thank you, sir. You're requesting an adjournment now.
We are, Your Honor, for discovery purposes, and I would also ask to briefly address bond.
Probable cause conference in this matter will be adjourned to March 20th, 2025, 9 a.m. Yes, that's the bond.
Your Honor, we are requesting release on tether, a personal bond with a tether. My client, we have information that the complaining witness has left the state. He would like to go back to his home. He's very concerned about losing his home and his car, essentially most of his life in custody for longer. He is involved with this church. He's sober and he understands he has to come to court in the future. So we're asking you to consider release on a tether.
Response.
Your Honor, I would object to any modification of bond. In this case, the victim had been trying to leave the defendant because he had been mentally and verbally abusive. He became upset at the victim, pushed her on the bed, grabbed her neck with both hands and strangled her. He was holding her down on the bed, and the victim described it as he was staring through her as he was strangling her. Afterwards, she thought she was going to die, and she called the police, but she was afraid he would hear her. So that she then drove to the police department to report the strangulation. She had red marks and scratches on her neck, and she said during the strangulation she began to lose consciousness and couldn't breathe, and remembered the defendant saying he would kill her. So I have very extreme concerns for her safety, even though she might not be in the state because of this event, Your Honor.
Anything else?
We're aware of the allegations in this case. I do think that a tether to his residence would protect both the complaining witness and the community in this case.
Motion for bond reduction is denied. Bond will continue. Thank you.
Thank you, Your Honor.
Your Honor, what was the date on that?
20th.
Thank you.
Court calls the case, People versus Matthew Gibbons.
Morning, Your Honor, Raymond Cook for the people.
Jake Kilwell, Judge, first of all, my apologies for being late today. I'm on one of the cases. PD has two. My case is 25 F5 5038.
I'm sorry.
No, go ahead.
Assistant Public Defender Chelsea Vergils with and on behalf of Matthew Gibbons on the older case.
All right.
Judge, on my case, Matt, you want to sign this? We're going to waive up the circuit court on. Judge, on my case, Matthew have decided that we would waive up the circuit court.
On 5038.
Yes, Your Honor. And he, for the record, he signed the waiver.
All right, what are we doing on the other two?
He would like to set a preliminary exam on his other two cases.
All right, so let's get the waiver out of the way. This is the case involving the possession of a controlled substance.
Correct.
So you're on that case, you're waiving your right to a preliminary examination?
Yes.
And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
And you understand you'll not have that hearing on this case and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right on that case.
Yes, Your Honor.
Preliminary examination having been waived, defendant's bound over on the single count on that case.
Oh, Your Honor, acknowledge to receive the information, waive its reading. My client would stand mute.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial in that matter will be set for
25th at 1:30 before Judge Cook.
March 25th, 2025, 1:30 before Judge Cook.
Thanks, Judge. Just speak.
Bond will continue on that case. On his other matters, counsel discovery is complete.
I'm sorry, Your Honor. I'm getting new information currently. Do you mind briefly passing this matter so I can speak?
Yes, I do.
Just waive it. Waive it.
I'm getting new information and I'm understanding that Mr. Gibbons would like to now waive his exam in the cases I represent him on. I would really appreciate a brief chance to talk to him about this new information.
Okay, never mind. Never mind.
Pass it.
Thank you, Your Honor.
Nah, just. Court does call the case People versus Annette Harrison.
Andrew Turner is appearing on behalf.
Your Honor, Assistant Public Defender Jay Bellinger on behalf of Ms. Harrison. Ms. Harrison, can you please state your name for the record?
Lynette Harrison.
Thank you.
And Your Honor, at this time, we are asking the court to set this matter for a preliminary examination.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available the 18th.
Yes, Your Honor.
Preliminary examination will be set March 18th, 2025 in person. That's at 9 a.m. before Judge Barr. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case of People versus Tyler Henry.
Morning, Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Laura Yagi, Assistant Public Defender with and on behalf of Mr. Henry, who is approaching. Can you state your name for the court?
Tyler Henry.
Thank you.
Your Honor, the people have extended an offer in this case. I have asked if they would hold it open till the exam. They indicated they would. So at this time, we would ask that this case be set for preliminary examination.
All discovery is complete.
To my knowledge, Your Honor, yes.
Yes, Your Honor.
People have their witnesses available the 18th.
Yes, thank you.
Preliminary examination will be set March 18th, 2025, 9 a.m. in person before Judge Moore. Bond will continue.
Oh, Your Honor, would Your Honor can entertain a motion or not?
Briefly.
Okay, very briefly. Mr. Henry, just in full candor, does have a few holds. We're not sure if they would actually come get him at this point. This is a case from 7 years ago, from presenting a false $100 bill to the big boy. The big boy has since closed down and no longer exists in Washington County.
So that makes it less of a crime?
It doesn't, Your Honor.
Okay, go ahead.
Mr. Henry's in custody because he failed to appear previously. He does.
Where's he been for the last 7 years?
So he has been working. He's been living in Taylor, Michigan, which is the residence he'd return to if he is able to be released. He's a father. I have been trying to get in touch with his family. Unfortunately, haven't been successful with that, but he indicates that he does have a stable residence he could return to as well.
Why didn't he turn himself in?
I actually did turn myself in once, and then you guys didn't come pick me up. One time I was in the Inkster, I think jail cell once, and you guys didn't even come pick me up. I watched my day.
They advised you, released you, and told you on and take care, right?
Yeah, I didn't.
Yeah. Did you come to Washington and take care of it?
Oh,
no, you didn't. Okay, go ahead, Mr. Yagi. Anything else?
No, Your Honor.
No, I don't need anything from the people. Motion for bond reduction denied. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case People versus William Johnson.
Alexander on behalf of people.
Rainbow on behalf of Mr. Johnson. Just state your name for the record.
William Johnson.
Thank you.
Your Honor, we're asking for this matter to be set for exam. To my knowledge, all discovery is complete.
People have their witnesses available the 18th.
We'll try our best, Your Honor.
Preliminary examination in person will be set March 18th, 2025, 9 a.m. That's before Judge Barr.
Your Honor, may I address bond?
Sure.
Thanks, Judge. Mr. Johnson is asking to be released. He indicates to me that he can reside with his mother in Charlotte. His mother is here in the courtroom, and she confirmed that today. He also indicates to me that he has a job that is waiting for him, or at least potentially waiting for him at a wastewater treatment plant in the Charlotte area as well. He's 33 years old, has 5 children, none of them with the complaining witness in this case. There'd be no reason for him to have any contact with the complaining witness. He would comply with all the conditions of bond set at his arraignment. So we'd ask the court to consider releasing him on a personal bond with tether of people.
Your Honor, we would be opposed to any modification of bond. In this case, the argument began, the victim was trying to avoid the defendant, and he ended up going outside, coming back inside, beginning to yell and spit in her face. Then had distracted her with opening trying to get him away from her. He then threw a bottle of hot sauce, a can, and a shelf at the victim. She then went to her daughter's room to get away from the defendant. He then kicked open the door to that room, pushed the victim into a wall, and began to strangle her with both hands around her neck and holding her up against the wall. She had to trip him to get away. He then began kicking and stomping on her ribs, and she started having trouble breathing after that as well. And her daughter had to call 911 to get the assault to stop. So I have great concerns, Your Honor.
Anything additional?
Nothing further, Judge.
Motion for bond reduction is denied. Bond will.
Thank you.
Thank you, Your Honor.
Court calls case People versus Robert Lewis.
Ashley Lonnie for the people.
Assistant Public Defender Chinanta Carey, I can really, Your Honor, on behalf of Mr. Robert Lewis on all matters. Mr. Lewis, your name for the record, please.
Robert James Lewis.
Judge, we respectfully request that all of these matters be preliminary
All discovery is complete.
to our knowledge, Judge.
And all these matters with the people have their witnesses available the 18th.
We can try for that date, Your Honor. Thank you.
Preliminary examination in this case will be set March 18th, 2025, 9 a.m. That's in person before Judge Moore. Before Judge Moore, bond will continue.
Thank you, Your Honor.
Your Honor.
Thank you. Did you need some? Court calls the cases of the People versus Lee Patton.
Alexander on behalf of people.
Assistant Public Defender Constable Basie on behalf of Mr. Leandre Patton, who is present to my right. Can you state your full name for the record, please?
Leandre Patton.
Your Honor, at this time, would you respectfully requesting to set this for a preliminary exam?
In both cases?
Yes.
All discovery complete?
To my knowledge, yes.
People have is available the 18th.
And may we briefly address bond?
Preliminary examination in this matter will be set March 18th, 2025, 9 a.m. Those are in person before Judge Barr. As to bond.
Yes, Your Honor, my client is asking for a PR bond. He has a child that he's expecting in 2 months. He has a job waiting for him on the outside. He has a family that he wants to support. He would be willing to go on a GPS or a hot zone tether or whatever the court may deem appropriate for him to get a PR bond.
Response.
Your Honor, I would object to any modification of bond in these two cases. The first case, the defendant had went to the victim's residence, tried to open the door, she found the door closed, and she had kicked down the door. She then tried to barricade the door with objects in the home. He still managed to break in, left when police arrived. While she was on the phone with 911, in that case, he took her phone and destroyed it. Then in a later case of 2025, he went to her residence, took her phone, credit cards, ID, and left, and he didn't have permission to be there or to take those items. He also has case convictions for a CSC first and an AWIM 2002, a CCW from 2020, and then a CCW in possession by felon from 2018. So I would just object to any modification of bond, Your Honor.
Anything else?
Nothing further.
Motion for bond reduction denied. Bond will continue. Thank you. Court calls case People versus Jeremiah Sawyer.
We're ready.
Is Miss Mackey lost her voice?
Well, actually, she's on spring break. She's doing us an honor by showing up.
So that she goes on spring break, so she doesn't have to do anything.
No, not at all.
Not at all?
Not at all.
Because of the school calendar?
Yeah.
Huh? Whatever, must be nice to be the princess. Go ahead.
Good morning, Your Honor. Ashley Lonnie for the people.
She called me a princess. And Laura Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Sawyer. Your Honor, we would respect.
Mr. Sawyer, can you state your name, please?
Yes.
Jeremiah Sawyer.
Thank you.
Your Honor, we would respectfully request that this matter be set for a preliminary examination at the earliest possible date.
All discoveries complete.
To the best of our knowledge, Your Honor.
People have their witnesses available the 18th.
We will try for that date, Your Honor. Thank you.
Preliminary examination in person, March 18th, 2025, 9 a.m. That's before Judge Moore. Bond will continue.
Thank you. We won't be addressing bond.
Okay. She's telling you what to do?
Ms. Mackey would like
No.
to know that she's working.
Oh.
I mean, I hadn't seen it. I hadn't noticed, but you know.
Wow. So she tells you, tell the judge this. And he just jumps right up to the podium. I know, Your Highness. She got to that level.
I learned from Mr. Brown.
No, not all that. Some of that just comes natural. Court calls the case B versus Justin Tittle.
Good morning, Your Honor. Victoria Burton here, Chief Assistant Prosecutor appearing on behalf of the people.
And good morning again, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Tittle, who's approaching the podium. Could you state your name for the court?
Justin Lee Tittle. Thank you.
This matter was adjourned previously for discovery. The people have, we have an update on discovery. So at this point, we would ask that it be set for exam. And we believe that we have all discovery that is available.
I don't know what that means. All right. So discovery at this point is complete.
As far as we are aware, the discovery we were looking for is no longer in existence. So we believe that it is.
People have their witnesses available the 18th.
We will do our best, Your Honor.
Preliminary examination will be set March 18th, 2025, 9 a.m. That is before Judge Barr. That's in person. Bond will continue.
Thank you, Your Honor.
Court calls the case of the people versus Michael Ware.
Ashley Laudner for the people.
Brian Boley on behalf of Mr. Ware. And who's coming?
Okay. I don't know what's going on.
Okay, I'm coming.
State your name.
Michael Ware. Thank you.
Judge, we're requesting an exam. To my knowledge, all discovery.
People have their witnesses available on the 18th.
We'll try for that date, Your Honor.
Pardon?
We'll try for that date, excuse me.
All right. Preliminary examination in person will be set March 18th, 2025, 9 a.m. That's before Judge Moore.
Thank you, Your Honor.
Bond will continue. Thank you. Court calls case of the people versus Jerry Ashley. When you get it.
On behalf of the people.
Assistant Public Defender Chinaza Carey, I can really honor on behalf of Jerry Ashley.
We did not sign in.
Oh, this is a Wayne County.
I'm back over. Yeah.
Okay.
It's over there, but
Okay, it's over there, so you
Yep.
gotta get that.
you're down to just recalls.
Yes.
So Mr. Gibbings, that's Mr. Geo's recall. They have Mr. Gibbings.
Are you ready on Gibbings? Court recalls case people versus Gibbings.
Good morning again, Your Honor. Raymond Cook for the people.
Assistant Public Defender Chelsea Vergil with and on behalf of Matthew Gibbings, who approaches. Mr. Gibbings, please state your name.
Matthew Gibbons.
I apologize for the delay, Your Honor.
No, it's all right.
He would like to waive his right to a preliminary examination
In both of these cases?
in both, Your Honor.
Is that correct, sir?
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution as you did in the other matter?
Yes, I do.
Okay. People also waive their right? in this
Yes,
case?
Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court in the 3 counts between the 2 cases. Ms. Vergils.
We acknowledge receipt of the information, waive its formal reading, and stand mute as to the charges.
Defendant every way formal reading standing mute as to both as to all counts, I should say. Pretrial in these matters will be set for
March 25th at 1:30 before Judge.
March 25th, 2025, 1:30, Judge Combs. Bond in these cases will continue. Thank you.
Thank you, Your Honor.
They're all recalls.
Oh,
Yeah,
gotcha.
2 different people, yeah.
I just flipped the B in this. Court calls the case, recalls the case, People versus Sheldon Burnett.
Andrew Childers appearing on behalf of the people.
Brian Bowling on behalf of Mr. Burnett. For the record again, please.
Shell.
Your Honor, thank you for passing this matter and recalling it. At this time, my client will waive his right to the exam.
Is that correct, sir?
Yes.
And you understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
Thanks, Judge. Waive formal reading, stand mute, ask for a pretrial date.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for April 24th, 2025, 1:30.
Thank you, Your Honor.
Bond continued. Appreciate it. Court does call the case People versus Nathan Burns.
Andrew Childers appearing on behalf of the people.
And Assistant Public Defender Tanaka K. Akinrumi on behalf of Mr. Nathan Burns. Mr. Burns, state your name for the record, please.
Hello, Nathan Byrne.
I have a plea form. Is that what?
That is correct.
Plea form indicates that the defendant will be pleading 2 counts. And added count 4 and 5. The first charge is attempted resisting and obstructing a police officer. It's a 1-year misdemeanor. I think the fine is wrong on here because it should be a $1,000 fine. 1,000 for 1 year, $1,000 fine plus court costs. And the count 5 is operating while visibly impaired. That being the 93-day misdemeanor. Upon a successful plea to those charges, counts 1, 2, and 3 would be dismissed. There's further the agreement, no delayed or deferred sentence. That's court's full understanding of the agreement.
That's our understanding as well, Your Honor.
That's correct, Your Honor. Thank you.
All right. They haven't sworn.
And do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Nathan Burns.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to 2 charges. Is that correct?
Yes, sir.
First charge is that of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court cost. You understand that?
Yes, sir.
All right. The second count that you'll be pleading to, the added count 5, is operating while visibly impaired. That's a misdemeanor punishable by up to 93 days jail, up to a $300 fine plus court cost. Court could order any rehabilitative services or community service the court deems necessary. Court could also order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, sir.
Understanding all of that, do you still wish to plead no contest?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
All right, 2 things about it I have to make sure you understand. The first thing is that it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, sir.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
To the chart, well, and I also had to advise you, you understand I would not be your sentencing judge.
Yes, sir.
And that while I'm taking your pleas, you would be sentenced before Judge Washington in the 14B District Court.
Yes.
All right. So, sir, to the charge of attempted resisting, obstructing, how do you plead?
No contest.
To the charge of operating while visibly impaired, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights for every day, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on the floor.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And, all right. Court has been provided Michigan Department of State Police report for their case number 8086-24. Any objection to the court has?
No objection, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine defendant's guilt of these offenses. Counsel, have I complied with the court rule?
Defense is satisfied as well, Judge.
Court will accept the defendant's plea of no contest to counts 4 and 5. Counts 1, 2, and 3 are dismissed pursuant to the plea agreement. Pre-sentence investigation and report is ordered as well as screening and assessment. Sentencing in this matter will be April 10th, 2025, 10 a.m. before Judge Washington. Bond will continue.
Judge, can I address bond just very
Want me to lock him up?
No, absolutely not, Your Honor. Mr. Burns tells me that he is scheduled to lay his mother to rest on Saturday this week. He is also on his way to the Air Force, right? To the Air Force. So he will begin basic training on March the 25th. That is going to be in San Antonio, Texas. In regards, he wanted to see if we could get the sentencing date, but we'll just contact 14B to get a better date for that, unless this court could do something about that.
No, I don't have another day.
Okay.
Because he has to go through the screening. Somehow they'll have to figure out how to try to work that.
Absolutely. And I'll explain that to him, but he just wanted permission to be able to travel to San Antonio, Texas on the 25th. You know when you'll be back? July the 9th is his return date. How long is basic training?
I don't.
Okay.
Talking about.
He's going to basic training in San Antonio, Texas for 8 weeks, Your Honor.
Correct. But he's trying to leave before his sentencing, right? That's currently set.
That is correct.
So you're gonna have to address that with
Okay.
Judge Washington.
No worries, Your Honor.
Okay.
I will reach out to the court and let them know.
All right.
Thank you, Judge.
Thank you. Thank you. Ready on this one. Court does call the case People versus James Falconport.
Good morning, Assistant Special Attorney.
And Christina Costantino appearing on behalf of Mr. Backelpour. Looks like they are probably going to get him.
Oh my God.
Okay.
No, I didn't.
While we're waiting for council approach, does call the case of the People versus James Falconport. This is a.
Christina Costantino on behalf of Mr. Backelpour. Mr. Backelpour, can you state your name for the court?
James Backelpour.
All right. And the record should reflect we've had extensive bench conferences regarding this matter. There may be argument made at a later time, but there's a request for this, and I think that's appropriate. Is that correct?
Yes, Judge. And if the court would consider 1 week so we can
Yes.
come back to readdress the bond issues, I would appreciate that.
All right. I will adjourn it to March 13th, 2025, 9 a.m. Thank you both. bond will continue at this time.
Thank you very much, Judge.